makes the premise of our conversation. And these 4 points, the 4 questions I have raised, will be the perimeter for the discussion. And let me straight away go to Deepika Narayan Bharadwaj. So, the first question I would like to ask you is dowry law, Deepika, effective? And we'll take all of them one by one in a round. To you first.
Karthikeya, I'm coming from very personal experience of the cases that I handle. I think dowry law has been effectively reduced to kind of a joke of a law in its current scenario. Let me first tell you that the initial laws that you shared, those are actually a lot of different provisions. There is Dowry Prohibition Act 1961. There is 498 of Indian Penal Code, which is now 8586 Bharatiya Nyaya Sanhita. Then there is Domestic Violence Act, Protection of Women Against Domestic Violence Act 2005. Uh, now, now, all of these cases, and dowry death is altogether a different provision, which is IPC 304B. I don't know what is the section now in the Bharatiya Nyaya Sanhita, but that's a case in which a woman dies an unnatural death, and the complaint is made that she was being harassed for dowry. The law that we are talking about, or that was applied in Atul Subhash's case, was essentially 498A of Indian Penal Code, which has been slammed time and again by the high courts and the Supreme Court of India. And all of these cautions that you were sharing have essentially come in the pretext of misuse of IPC 498A.
Okay. So, okay. So, you are saying
Now,
that, okay. No,
having said,
let's go
there
point
could
by
be
point.
hasty
Deepika,
counts in law.
Deepika, let's go point by point. So,
Yeah,
essentially,
Karthikeya, yeah,
Deepika, please.
yeah,
There are other people. Essentially,
yeah.
essentially, you are saying that it's hard and it gets misused. Let me go across to Rekha Agarwal. Madam, the issue is, has it done well for the Indian women, or has it not done well for the Indian women?
I'll answer the question both in yes and no. There was a time when this law was made for the first time, Section 498A. There was a reason for making this law when there were a large number of cases where women were actually undergoing what are called dowry deaths. The term dowry deaths came into existence only because at some point of time, there were a number of women who would just die because a cylinder would burst or a kerosene stove would burst, and it would be passed off as an accident. But whereas the truth was that these women were actually murdered or harassed and suffered so much of cruelty at the hands of their husbands and in-laws, that a number of women, especially in the early years of their marriage, were facing this kind of a mental and physical cruelty at the hands of their husbands and in-laws. And ultimately, Section 498A, a special section was incorporated in the Indian Penal Code to face this particular problem of dowry deaths, where the deaths were occurring because of the demand of dowry that brides were facing, particularly newly married brides. But at that point of time, let us say that the scenario has certainly changed over the years. More and more women, and now living in a metro, I speak more for the metro women or the urban women. I do think that, and I'm not making out a case either for Atul or for Nikita, the complainant in the present case, but I would say that more and more women who are living in urban and metro cities do not really need the kind of protection that Section 498A Indian Penal Code, the erstwhile penal code, that was giving to them. Because now what is happening is more and more a compatibility problem, compatibility issues which are there in young couples, particularly. And and now once there's a breakdown of the matrimonial relationship between the parties, it's always as a all hell breaks loose. And as I say, there's no greater fury than a woman scorned. So it may be for any reason whatsoever, but when there's a problem, women do come out with a vengeance, and they have to go to the court. So now whatever sections are there in law, the lawyers will draft a particular complaint based upon those sections and bring the complaint around to meet, come within the parameters of that particular section of law, whether it be dowry prohibition law, whether it be 498A, or whether it be the Domestic Violence Act, etc. So, what I would like to say over here, that Section 498A particularly, which has time and again been used. At one point, it was being used in a proper manner, but now, as a lawyer and with my experience at the bar now, almost 37 years, I would say that yes, I do agree that there is a rampant misuse, and girls who are otherwise economically strong, and advanced, educated, they have the protection of their families. They're not bichara women, they're not abla
Madam,
naris.
bas-